Hello, everybody. We're going to be talking about Chapter 10 from our textbook, California Real Estate Law by Walt Huber and Kim Tyler. This chapter is titled Title and Alienation, and it discusses different ways in which that title is held, and we also learn about different kinds of alienation that exist, which just basically means the different types of ways that we can transfer ownership of property. We learn about voluntary alienation, involuntary alienation, and the recording process that goes on to hold ownership, and essentially meaning that we hold title. So voluntary alienation happens in a legal manner, requiring that a valid deed exists, which means that it must be written, have conveyance, a competent grantor, identifiable grantee, adequate legal property description, and have an explanation of the delivery and acceptance. There's different kinds of deeds that can exist for this that include grant deeds that are warranty deeds, quitclaim deeds, and after acquired title. There are also the methods of a will, where voluntary alienation or transfer of the ownership of a property can happen. So basically that could be something like family rights. There is also involuntary alienation, where ownership of a property is passed down without identification of the designee or acknowledgement of the designee to know that it exists. This could be something like that happens with succession from adopted children, half-brothers and half-sisters, legitimacy of divorce and stepchildren, where individuals who are not considered as having family rights under a will can contest to have the ownership of the property, including real property, in this way. So they would go to court and have the transfer of ownership via the court decision. The court decisions also include things like foreclosures, partitions of property, and quiet title transfers. Huber and Tyler also go on to explain adverse possessions. That's when we're discussing public lands and the requirements of how to attain a property through things such as payment of taxes, like property taxes that are unpaid can be paid out, and the ownership can be transferred in that way for property that's outstanding in that way. And so that's a method of obtaining ownership of a real property. And lastly, this chapter goes on to discuss the recording process, and it identifies the recorder's office at the county level as the location to obtain indexes and plat maps. And we can also expect that notices are coming from this office to identify different rules, recording issues that can be reported here. So just to briefly recap, a deed is something that must be in writing, signed by the competent grantor, have words of conveyance, and adequate property description naming the identifiable living grantee. It's a way for a title to be transferred or alienated from one ownership to another, and it doesn't become effective until the grant is delivered to the grantee with a donative intent. And that the grantee accepts it. In California, there are certain deeds referred to as grant deeds, quitclaim deeds, and acquired title, where there are different types of warranties implied, limited warranties versus none at all, or fully warranted. This is the summary of this text for this chapter is on page 387 to go over what I just went over. I'm just highlighting things that I found most important, concepts that may be on the real estate licensing exam. And another thing to highlight are the wills. The wills also must be in writing. It must be via witnesses, unless it's a holographic will where it doesn't require the two witnesses, and you can expect that a real estate attorney would be the one to have that enacted and hold it within deed.